Like and subscribe to my channel and click the bell icon to get new video updates.
Opinion Supreme Court case puts immigrant hawks against freedom of speech. In the United States v. Hansen case, the judges have an opportunity to take some important constitutional action. It concerns a law that would encourage or induce an unauthorized immigrant to enter or reside in the United States to stop him is guilty of a federal crime punishable by up to 5 years in prison. Of course, jails are not overcrowded with people who advocate amnesty or urge a friend, relative, or client to overstay a visa. The law will usually list it as one of several criminal offenses in the indictment of immigration fraudsters like the defendant in that case, Hansen, who was also convicted of 15 counts of fraud for selling immigrants a false route to citizenship in California. But Mr. Hansen objected to that clause, encourage your cause to be too broad, and therefore likely to discourage the First Amendment protected speech of others. We have a glimpse of the judge's reasoning ahead of next month's hearing, because they heard an analogous case in 2020, and then dismissed it on procedural grounds. Judging by the reasoning in this case, several judges are alarmed about some of the implications of the law, and are keen to limit its reach, although how they might do so will be heavily disputed. The simplest option is to declare the law unenforceable because of its encroachment on the First Amendment. The Biden administration claims this would undermine its ability to control immigration. However, other provisions of the Immigration Act already prohibit bringing unauthorized immigrants into the United States, concealing them, and aiding or abetting these crimes. Ninth Circuit Judge Ronald M. Gould noted the government's failure to identify any instance in which the clause was the only available statutory provision punishing deplorable conduct. They could instead interpret the law as prohibiting incitement to commit a crime, a category of speech that lacks First Amendment protections, but requires closer coordination between the speaker and the would-be lawbreaker than mere encouragement. But is such a constitutionally flawed clause really worth saving? Although entry without a permit is a criminal offense, staying in the country is usually only a civil offense. A judicially rewritten poaching law would usually prohibit behavior that other parts of the law already prohibit. And if the law remains in effect, an ordinary person reading it, unlike the judge's translation, might still be reasonably unsure whether it criminalizes innocent speech. That goes to the broader use of this case. A Heritage Foundation study estimates that through 2019, Congress created 5,199 federal crimes, a 36% increase since 1994. Many of these crimes are vague and duplicated. The clause in question applies in any case. The result is the consolidation of the prosecution and the erosion of civil liberties.